What's going on, good people? It is the Bad Wolf, howling mad, just a madman in a blue box. But the box can be any color or look like anything I want. Okay, well, that's kind of a reference to Doctor Who for those people who get it. So anyway, we are going to be continuing. Now, this particular segment is going to be called Defense to Unlawful Arrests. All right. So for those who don't know, we have had 90 to 95% success with all this information, with all the remedies for your liberties, rights, and justice under the Constitution. I'm seeing people all over using my information, using my verbiage, mentioning me on their shows, asking me to be on their shows. It's getting a little crazy. It's getting a little crazy. Um, as always, guys, this is educational information only. We are not belligerents, nor combatants, nor sovereign citizens. We are private sector, nationals, and state citizens. Sovereign citizen is an oxymoron. You cannot prosecute somebody on something like that which does not exist. It's imaginary. It has not been adopted by law to have any standing. Okay. So, but what they're really trying to say is that you are a 14th Amendment U.S. citizen in their jurisdiction and you're not properly removing yourself or operating that which can be construed to be in their jurisdiction and underneath their claim. So you should not ever mix the public and the private. You can't be like, oh, I want my vehicle to be like with their plates, but then I want to be private with no, one or the other. Stop asking me these questions, guys. Like you can't mix things, okay? Once again, throwing it out there. Sorry, not sorry. If you make a cake or grandma makes her favorite cake and you put some dog crap in it, is the cake good? Are you going to eat it? No, maybe a hog or a dog or something would still, but no normal person would. Why? Because you are mixing two things that do not go together, the public and the private. When you're operating as a public person, like a police officer, sheriff, lawyer, judge, postal worker, um, you're in the public. You are a public trustee. And when you use your all capitalized name, you're operating as a public entity. You just didn't know that because they wanted you to be on their team to add in some of that tax money and their jurisdiction over you. But you are, in fact, a private Native American if you're born here or you are naturalized as a state citizen. All that kind of goes together as being called a national. We've already seen and proven that in the government's GPO Styles Manual underneath Section 5.23 under nationalities. We know what we are. Problem is you don't know who you are. And this goes out there to the police officers and whatever else, because you know what? When you're on duty, you're public. When you understand this information, you're private. They don't want you to know because then you're going to be operating under the Constitution. And then you're not a traitor because then you understand constitutional rights and laws. You understand statutes and codes and regulations under the state, which has the authority given to it by the federal government, which it was given this authority by we the people and reinforced and protected by the Constitution that I just showed you a moment ago. The states have the ability to do what they're doing, but not when it deprives you of your constitutional rights and liberties and your pursuit of happiness and your right of travel. So yes, you officers can also, which many of you guys have reached out to me. Thank you for those people who just want to honestly know what's going on. You can do these same things in the private, but not with your police cruiser, not when you're on duty. You cannot get out of taxes because you are a sworn in public officer. We, the people, when we know who and what we are, have the ability to operate and move all of our things to the private side. You have that capability. But when you deny somebody of these things, you are committing federal offenses. You're breaking constitutional laws from lawful opinions. Okay, when I say opinions, that means court cases. They don't call them court cases, they call them opinions, which is the highest law of the land, supported by the district courts. Did you forget you were an American? Oh, you thought you were because you do stuff that looks like it's American because it has American sounding names in there, but go through your paperwork and see where you find the word America on there anywhere. Oh, but you see the United States. Well, did you know there's 3 definitions of the United States? The corporation located in the District of Columbia that we do not own. The body politic, Congress, and the geographical United States of America. Those are 3 different things legally. I read the court cases from the Supreme Court. The United States, meaning the corporation in relationship to the United States of America, is in fact foreign. Those are 2 separate things, different jurisdictions. But I digress. Let's get to why you guys came here. So once again, defenses to unlawful arrests. And this is education too for my fellow family members and friends out there who are police officers and those people who are just interested. Because I really don't want to see you guys prosecuted for stuff and lose your stuff, your house, your family, your significant other, your bank accounts, and whatever else either, because you are an American and you guys are being duped by people who don't want you to know these things because they want you to be blind dogs on the side of the road doing what they want, their bidding, because they get you get into trouble, not them. They're just going to say, well, you didn't learn, you didn't do your job right, and they're going to burn you. So I'm trying to prevent you guys from getting a burn notice. So like it, love it, or leave it, as they used to call me in kindergarten. But the truth is the truth is the truth. And if it hurts and you get offended by my information, good. You should be stirred. You should be disturbed. Well, if you use quantum grammar, it should actually be turbed. But anyway, we'll leave that alone for now. So once again, from your favorite non-belligerent, non-combatant, IQ of almost 160. And somebody who loves this stuff and speaks more than one language and has read a lot and has beaten judges and lawyers to the point where they've asked me to join them. And I turned them down because I like to do this for the people. Because if I'm one of them, then I can't do what I'm doing here now for you guys. So once again, hit that bell, like, and subscribe. Share the videos with those people who you know will appreciate and can use it. Stop sharing it with people, police officers who don't want to hear this. They're not going to hear this information. They have their blinders on. But those who are open, cool. And I thank you guys for taking that step, as difficult as it may be. For the rest of the people out there, take care of yourselves. And I appreciate you guys for supporting me in any way, shape, form, or fashion. Now, with that being said, let us get into the video. Let's go.
Defenses to unlawful arrests. This section will be of benefit not only to those who may initiate a suit for false imprisonment, but also for peace officers, as it further outlines what is the extent of their authority.
Told you.
Suits are usually brought about because there is not a meeting of the minds in regards to the facts or the law of a case. If both parties know the law of arrests and what can and cannot be used as a defense to acts of imprisonment, many lengthy and costly litigations can be avoided. Over the course of the history of arrests, there have been numerous defenses raised against claims of false imprisonment. Yet the basic defense for this charge is usually limited to showing that the arrest was pursuant to law, that the one arresting had lawful authority to so act. Thus, a valid defense or proper justification for false imprisonment would normally be one asserting the legality of the arrest. One is just as Hand stated, the law watches personal liberty with vigilance and jealousy, and whoever imprisons another, in this country, must do it for lawful cause and in a legal manner. Point 2. Most of the erroneous defenses have been due to misconstruing the requirements of a suit for malicious prosecution with those required for false imprisonment. Burden of proof. In false imprisonment suits, or in allegations of false arrest, it can be no defense that the one who was arrested must prove that the arrest was unlawful in order to prevail in the suit. Due to the high regard placed on liberty, all imprisonments of a person are deemed unlawful until the contrary is shown. In Halsbury's Laws of England, in speaking on suits of false imprisonment, it says, the plaintiff need not prove that the imprisonment was unlawful or malicious, but establishes a prima facie case if he proves that B was imprisoned by the defendant. the onus then lies on the defendant of proving a justification. 3. The only thing the plaintiff needs to plead and to prove is one of two things: either 1. That the defendant made an arrest or imprisonment, or 2. That the defendant affirmatively instigated, encouraged, incited, or caused the arrest or imprisonment. For when the plaintiff has shown that he was arrested, imprisoned, or restrained of his liberty by the defendant, the law presumes it to be unlawful, esse. Thus it has been held that in false imprisonment suits the defendant, in order to escape liability, must either prove that he Marks v. Ballamort and 0. R. Company, 131 N.Y.S.2d 325, 327, 284 app.div. 251, 1954. 2 Pratt/v. Hill, 16 Barb.Republic 303, 308, N.Y.1853. 3 Earl of Halsbury, That Laws of England, Volume 38, 3rd ed., pt. 4, Section 1266, page 765, London, 1962. For Burlington Transp. Company v. Joseph Son, 153 Federal 2d 372, 276, 1946. 5 People v. McGrew, 77 calories, 570, 20 pack. 92, 1888, Knight v. Baker, 117 Oregon 492, 244 p. 543. Did not imprison the plaintiff or he must justify the imprisonment. 6 Stated another way, the burden is upon the defendant to show that the arrest was by authority of law. 7. In a case where 2 police officers arrested a man whom they believed committed a felony, the jury was instructed that the burden of proof, by a fair preponderance of the evidence, was upon the plaintiff to show that the arrest and imprisonment were not justified. This instruction was held to be wrong on appeal, where the court stated, "It was long ago said by Lord Mansfield, a jailer, if he has a prisoner in custody, is prima facie guilty of an imprisonment, and therefore must justify." Badkin v. Powell, Caup. 476, 478. So, in Holroyd v. Doncaster, 11 More 440, it was said by Chief Justice Best, where a man deprives another of his liberty, the injured party is entitled to maintain an action for false imprisonment, and it is for the defendant to justify his proceeding by showing that he had legal authority for doing that which he had done. Where the arrest was done without a warrant, the person arresting would have to justify by showing he acted pursuant to due process of law, by showing that there was a felony or breach of peace committed. Where an officer arrests a person without a warrant, the burden rests upon the officer to plead and prove justification. Otherwise the arrest is prima facie unlawful. 9. In a case in Iowa, to be mayor of Owen had instructed the town marshal to arrest a man because it had been reported that he was drunk. 33. And had been disturbing the peace. The marshal arrested the man in his home without a warrant. When the man sued the mayor and marshal for false imprisonment, the court instructed the jury that the burden of proof was upon the plaintiff, the man arrested, to prove that he was not found intoxicated when arrested. On appeal, the Supreme Court of Iowa held that the court announced an incorrect rule of evidence on the matter. The Supreme Court, in defining the correct rule, stated, in 2 Bishop on Criminal Procedure, Section 368, it is said, in matters of evidence, if the imprisonment is proved, its unlawfulness will be prima facie presumed, but authority may be shown by the defendant in justification. 10. If the marshal had a valid warrant, this would serve as justification for the arrest, and as a defense to the charge of false imprisonment. Being he had none, and he witnessed no breach of the peace, he had no defense against B charge. The rule of burden of proof is the same in a criminal proceeding, where any arrest made without a warrant, if challenged by the defendant, is presumptively invalid, and the burden is upon the state to justify it as one not only authorized by statute, but also as one not violative of constitutional provisions. The invalidity of the arrest will render the search invalid and the evidence obtained inadmissible. This was so held in Testelin v. State. 205 NW 825, Wisconsin 1925.
Always Wisconsin.
6 Southern Re. 34.
Y'all wild.
34. Good faith and probable cause. The most common defense raised in false imprisonment suits is that the arresting officer acted in good faith or with good intent. This argument of defense is often raised along with the defense that the officer had probable cause. Both of these defenses are often misapplied to the action of false arrest. Such defenses are more applicable to suits involving malicious prosecution or abuse of process, rather than to false imprisonment. As stated by the Supreme Court of Iowa, false imprisonment is the unlawful restraint of an individual's personal liberty or freedom of locomotion. The good faith of the actor is no justification, nor is the want of probable cause an essential element, as in the case of malicious prosecution. 12. In cases of false imprisonment, the only essential elements of the action are detention and its unlawfulness. Thus malice in the want of probable cause need not be shown. 13. Or are not necessary to a proper cause of action for false arrest, for even where the unlawful arrest is claimed to have been for the public good, such a defense will not stop damages. It is well set law that the want of reasonable or probable cause and the want of malice are elements not entering into the action of false imprisonment insofar as actual damages are concerned. 1s. The question of probable cause, in its usual sense, is not involved in the action for false imprisonment. High. Thus, according to the great weight of authority, the existence of probable cause is not an element of nor a defense to an action for false imprisonment. 17. A case in South Dakota developed where a sheriff bad, due to mistaken identity, arrested the wrong person as an embezzler upon a warrant which did not name or describe the person to be arrested. The sheriff alleged good faith and probable cause for arresting the man. The state Supreme Court held that the fact that the sheriff acted in good faith and with probable cause was no defense, and may not be taken into account in determining the damages which will compensate to be plaintiff. 18. In many cases, officers will try to justify an arrest for a misdemeanor based upon a strong belief that the person arrested is guilty. In such a case, the Appellate Court of Illinois held in an action for trespass and false imprisonment, probable cause and the absence of malice constitute no defense, and this form of action belief in the guilt of the party arrested, no matter how strong or well-founded in the mind of the officer or person making the arrest, will not justify the deprivation of another of his liberty, and it is unimportant whether the circumstances would lead a reasonable or prudent person. 12 Sergeant if Watson Brothers Transp. Company, 244 Iowa 185, 52N.W.2 D86, 92. 93, 1952. Citing, Maxwell if Maxwell, 189 Iowa 7, 177 NW 541, 1920. 13 Sinclair Refining Company. If Meek, 62 Ga App. 850, 10S.E.2 D76, 15 Carter if 16, 17 to believe that the accused was actually guilty. 19. In some cases, instead of asserting that the officer acted in good faith, the defense is raised that malice must be proven on the part of the arresting officer. This defense is, however, groundless in matters of false imprisonment. In an action for false imprisonment, neither actual malice nor want of probable cause is An essential element necessary to a recovery of general damages, i.o. Whatever the motives of the arresting officer, they do not cause or bring about a change in the legality of an arrest, as was asserted by the Supreme Court of Missouri. A lawful imprisonment does not become unlawful because of malicious motives, nor does an unlawful detention become lawful because actuated by a laudable purpose or founded in good faith. Point 11. Closely related to the defense of good faith or lack of malice is that an arrest is justified where there is no force or injury done to the person arrested. But as the United States Court of Appeals stated, this does justify an arrest. All that is necessary to establish false imprisonment is that an individual be restrained of his liberty under the probable imminence of force without any legal cause or justification.
Yes, sir.
It is not necessary to show actual force, threats, or injury done to the individual's person, character, or reputation. The lack of malice, the presence of good faith, or the presence of probable cause do not affect the existence of the wrong when the detention is unlawful. Point 22. 19 Morkey v. Griffin, 109 Ill App, 212, 1903. 35. Where a deputy game warden had arrested a man without warrant and incarcerated him in the county jail, the deputy claimed that at the time of the arrest he had probable cause for believing that plaintiff was then violating the law by hunting without a license. It was held that by hunting without a license. It was held that there was a false imprisonment involved. As the Supreme Court of Alabama said, in false imprisonment, the essence of the tort is that the plaintiff is forcibly deprived of his liberty, and the good intent of the defendant, or the fact that he had probable cause for believing that an offense was committed, and acted in good faith, will not justify excuse the trespass. Point 23. In an action against a mayor and a police court judge for alleged false arrest and imprisonment, it was claimed that the defendants acted maliciously with a design to injure the plaintiff. It was held by the Supreme Court of Kansas that based upon the claim of malice, the defendants were not liable for false arrest. The proper remedy would be an action for malicious prosecution. The court also stated, the motive with which a restraint of liberty is accomplished, be it evil or good, is irrelevant to the question of whether or not an unlawful arrest has been established. The existence of actual malice is of consequence only as it may afford the basis for punitive damages. Damages. In Garnier v. Squires 62 Kansas 321, 62 p. 1005, the court said, as will be second, malice and willfulness are not essential elements of false imprisonment, and motives of the defendant, whatever they may have been, are not material to the case. H. 20 MCN FF. IDER 337 p.2d 81-9, 821, Oregon 22-36, and the Court of Appeals of Maryland had stated, in false imprisonment suits, the essence of the law consists in depriving the plaintiff of his liberty without lawful justification, and the good or evil intention of the defendant does not excuse or create the tort. 11 RCL 791. Any deprivation by one person of i.e. liberty of another without his consent constitutes an imprisonment, and if this is done unlawfully, it is false imprisonment, without regard to whether it is done with or without probable cause. Point 2s. In a case of false imprisonment, the defendant claimed that the petition did not state a cause of action, for the reason that it was not alleged that the imprisonment was malicious and without probable cause. The trial court held that these claims were only valid in suits for malicious prosecution, and that there was a marked distinction between malicious prosecution and false imprisonment. The Kentucky Court of Appeals affirmed this position with various cites. In Starkey's Evid 1112, it is said, no proof of malice or want of probable cause is necessary to make a case for false imprisonment, 26. Where the life, liberty, or property of the citizen are at stake, good intentions are never good enough. It has been stated that the citizen's liberty must not depend upon good faith merely, but upon legal rules governing official action. 27. It has been held many times that in cases of false imprisonment, the defendant can only avoid liability for false arrest by pleading justification for the arrest. 28. All other arguments must necessarily fail. Ignorance of law. It is a fundamental maxim of law that ignorance of the law is no excuse to violating it. One such
And this means on the side of the public and especially doubly on the part of the officer. So we weren't trained in law. So how are we expected to know it? But they'll say, oh, ignorance of the law. You know who they're really talking about? Is you, the police officers, because you were taught in this. Well, at least more than the average person. So that's why they then try to protect them. Oh, well, so wait a minute. When we don't know the law, we don't get any protection. We just get all roughed up and whatever else and dealt with. But when they don't know the law, then they have bonds and insurance to protect them. But if you know what you're doing, why do you need protection? Same thing with these doctors. Why do you have all these insurances? Oh, because people make mistakes. Yeah, but see, then what about when we're out there and we just made a mistake? Shouldn't we then have some type of insurance to help us not have to deal with that? Well, yeah, there's no normal insurance that comes in with a monetary value unless, oh, what's that you have here, my good man? It says, what? Let me see this document. Oh, the Constitution. This is our insurance. And the federal government has a job, duty, and obligation to uphold this. Well, so do cops, because they all take the oath, but they just kind of go, well, whatever. Got to do my job. Where's our get out of jail card free? Where's oh because then once you know this, you can sue them. And unfortunately, though, I hate to be like this because I'm not a money grubbing type of person, but if they're going to deny you of your constitutional rights and they're not going to give you any remedy, then go get your money, go get paid, sue them in federal court, force them to make policy changes and to be re-educated because we the people are tired. And this goes out to any person who's against the American people and you're not a patriot and you're in our lands and you're doing business and you're depriving us of our rights and liberties and some people's lives and their justice and their families and their kids. We've had enough. Enough people out there are starting to learn this information. So the injustice that has been done, do you hear it? Did you hear that sound? Do you hear the roar of the quiet? That's the American people waking up. That's the dragon that is America. And people are starting to understand what I've been teaching for all my life is that America is inside of you. And when America wakes up, there's going to be hell to pay because the Americans are not somebody you want to mess with. And you've been messing with them, us, for far too long. And today's a new day. And each day we inch closer to taking back the country, knowing what's going on, and being private, autonomous citizens and nationals and getting things right. We don't like to be lied to. We don't like to be played. And we love winning. And there's more than one way to fight. So, that which has been heard cannot be unheard. The bell has been rung. The ripples cannot go back to the center of the pond. And they're setting out to do what they're going to do. Let's get back to the video, shall we?
Maxim is as follows: ignorance of the fact excuses, ignorance of the law excuses not. Every man must be taken to be cognizant of the law, otherwise there is no saying to what extent the excuse of ignorance may not be carried. Point 29. It has been said that an unlawful detention or imprisonment does not become lawful because done out of ignorance of the law. 30. The Georgia Court of Appeals BAS Beldtvat. It is no defense that a person perpetrating an illegal arrest or imprisonment is ignorant of the illegality of his acts. 31. Knowingly committing an arrest which is illegal is sufficient to fix liability. False imprisonment is treated as a ton, and also as a crime. If the conduct is unlawful, neither good faith, nor provocation, nor ignorance of the law is a defense to the person committing the wrong. 32. After speaking on the constitutional rights of citizens, the Supreme Court of Minnesota further adds: 25 Mahan vs. Adam, 144 MD 355, 124 all. 901, 905, 1924, cases filed. 26 Sol M. Re. A Company in Kane Lucky v. SHJRF, 121 Kentucky 863, 90 SW 597, 599, 1906, authorities. Ali is the case of illegal arrests. The officer is bound to know these fundamental rights and privileges, and must keep within the law at his peril. Point 3J. Ignorance cannot be an excuse for violating the rights of citizens or any constitutional mandates such as due process, especially by those who have taken an oath to uphold that law. They become a hypocrite upon the assertion of such an excuse. Guilt of party arrested. An unlawful arrest cannot be justified because the arrested party was actually guilty of the charge for which he was arrested. The person charged with an offense can only be deprived of his liberty by due process of law. And this constitutional safeguard applies to the guilty as well as the innocent. Thus, to be guilt of the one arrested has no bearing on the legality of an arrest, as stated in annotation 25A.Lr. 1519. No one can recover damages for a legal arrest and conviction. Therefore, in cases of meticulous prosecution, it becomes necessary to await the final determination of the action. But the same principle does not apply to an action for false imprisonment, as the form of action is based upon an illegal arrest, and no matter ex post facto can legalize an act which was illegal at the time it was done, comma, 4. Thus nothing that happens ex post facto, after the fact of the arrest, can change the legal nature of the original arrest. A prosecution and verdict of guilty does not make an unlawful. 37. Arrest lawful. In a case of false imprisonment where it was being asserted that the plaintiff was guilty, the Supreme Court of Oklahoma said, the guilt of the plaintiff is not material. JS in the Michigan Law Review it was stated that an arrest is unlawful, even though the arrestee be guilty of a felony, if the officer had not reasonable ground to believe him guilty. Thus neither the guilt nor innocence of the person arrested has anything to do with the legality of the arrest. 36. It thus been declared that in an action for false imprisonment, the termination of a prior proceeding in favor of the one deprived of his liberty is not material to his suit. 37. Since termination of the proceedings is not material, the fact that the one deprived of his liberty was actually found guilty is immaterial to the false imprisonment suit. But in a suit for malicious prosecution, there must be a termination in the proceedings in favor of the party deprived of his liberty to prevail. If he is found guilty, he cannot sue for malicious prosecution. A false imprisonment case in New Jersey occurred where a woman was committed to an insane asylum by a business partner, and was released a few days later by her bus band. The woman sued the partner for false imprisonment, but it was argued that the woman failed to plead or prove that the proceedings leading to her arrest and imprisonment in the asylum had terminated. The appeals court said that the argument raised did not apply to this case as it was in J. Theed H. Town 0/Scandia Valley, 217 Minnesota 218. 231, 14N.W, 2D, 400, 1944. 34 Sergeant Watson Brew. Transp. Company, 244 Iowa 185. 52N.W.2D 86, 9293, 1952, citing Navav. Costa, 5 calories, app.L11. 89 pack. 860, 1907. J.S. Halliburton Abbott CO. 2. Hodge, 44P.2D 122, 125, Oklahoma, 1935. 36 Michigan Law Review. Volume 31, April, 1933, page 750, citing numerous cases. 37 Reg/2. Highgrad Sud CQ, 47F.Sup. 290, 293, 1942, Thompson v. Farmers Exchange Bank, 62S.W, 2D, 803,810, MO. 1933, 25 American Law Reports, Annotation, page 1518. 38. Action for false imprisonment, and not malicious prosecution. The court held. The weight of authority is against the proposition that in a suit for false imprisonment the prosecution should terminate before a suit for damages can be instituted. 38. In a suit for false imprisonment, a record of conviction for the same offense for which the arrest was made is inadmissible. 39. An action for false imprisonment is to be based upon the legality of the arrest, not upon the filing of a complaint, or the proof of an alleged crime, or the results of a trial, as the California Supreme Court said. The finding of guilt in the subsequent criminal proceeding cannot legalize an arrest unlawful when made. 40. Even where a party has pleaded guilty, the one making the arrest can still be liable for an illegal arrest. 41. Thus it has been held that consent to an unlawful arrest will not excuse an officer or person from their acts, as held by a Federal Circuit Court of Appeals. We are of opinion that the law does not permit the citizen to consent to unlawful restraint, nor permit such a claim to be made upon the part of the defendants. In Wharton on Criminal Law, Volume 1, Section 751E, it is said, "No man has a right to take away another's liberty, even though with consent, except by process of law." And the reason is, that liberty is an unalienable prerogative of which no man can divest himself, and of which any divestiture is null. 42. Immunity. The argument of official immunity would seem to be an obvious and logical argument for an officer in defense of a charge of false imprisonment. Government is generally immune from being sued, and peace officers are regarded as members of government, thus it is often claimed they are immune from suit.
Generally. Catch the word there? Generally. That does not mean absolute, does not mean 100%. Typically, it means from the public side, because you're their property as a 14th Amendment U.S. citizen, not from the private side. They can still be held accountable. And if they don't do their job, they can still be held accountable. If they're gross in negligence or negligent, they can still be accountable. Even if you can't get them on the public side, you can go after them on the private side. File a lawsuit, a claim, liens, but only after you've been received your court decision. All right, don't just do these things in general. Okay.
Suit. But the immunity doctrine does not extend to anyone in government who causes a wrong, but immunity from suit is a high attribute of sovereignty, a prerogative of the state itself which cannot be availed of by public agents when sued for their own torts. 43.
Tort claim.
Under the doctrine of official immunity, there have been distinctions made between acts that are discretionary duties, which an officer in performance of is immune, and acts which are ministerial duties, for which officers remain liable. An officer's official duty is described as ministerial when it is absolute, sine and imperative, involving merely execution of a specific duty arising from fixed and designated facts. 44. An arrest by an officer is a ministerial, not a discretionary act. 38. Bosch versus Kick, 98 NJ Law 1.
That's it, guys. That is it. So hopefully you guys found that particular, like the glasses. I look cool now. Sorry. Yeah, sometimes my eyesight, actually, for those people who don't know, like I said, I keep it honest here. I do have astigmatism. So I do see things, forwards and backwards and whatever else. I don't think it's a negative thing. It's just how it is, how my brain works. But sometimes the light itself, actually, because of that, makes everything starry and whatever else. Feel like I'm on ecstasy or something like that. Not that I've ever done that. Yeah, well, I have. But it's been years. So, but like I said, just keeping it honest, because that's what we do around here. And if you've done something you're not proud of, well, then you probably shouldn't have done it in the first place, but keep it honest and keep it moving. All right. That's the whole thing. Everybody wants to be perfect and nothing's wrong with me, et cetera, et cetera. No, you call it out for what it is. All right, so that's it, guys. Let's see here. All right, so the next chapter is going to be the use of a warrant in arrests. All right, and that link should be popping up here. If not, once again, you can just find it under the use of a warrant in arrests by James C. Lovett, or so read by. Once again, we give a shout out to the creators of the document known as the Treatise on Arrest. So thank you for that in advance, for putting together a lot of great information, and most of which I already knew. Some of it I learned some new things, some new tricks and tactics to use in court and against officers who are operating in malum prohibitus. And also the court cases. That's what the parts that I skip on there are just the court cases. And you guys, no one's really wants to hear all that. But once again, I will be doing a video where I will be allowing the AI to read through the whole entire thing for those people who want a straight shot through. But as you see, it does take time, so I have to break things up into pieces. But it is what it is. So with that being said, guys, that's it. Don't forget to hit that bell, like, subscribe on the way out. Click one of these pop-up little thingies if you haven't already, and support. Appreciate you guys, and we'll be back in 2 and 2 for the next section. Talk to you guys later. Badwolf was out. Heard some of you guys missed me. You guys have been sending me emails, checking in. Yes, everything is well. I just took a break, from all of this, because you have to breathe, and spend time with the loved ones over the holidays, friends, family, and just by yourself sometimes, and get away from the YouTube haters and the world haters and whatever else. Because it's funny how nobody really cared. Nobody cared who I was until I put the wolf mask on. And then now that the channel's getting so popular, we're heading towards skyrocketing towards 100,000, which I never thought it would get there, but it's nice that we are. Not so much on the, I don't know, on the pride side, just on that you guys are finding this information useful, because it is, and that it works because it does, and it's your right because of the Constitution and your God-given. And saving you guys time for having to, look the stuff up for yourself. So once again, support me any kind of way you can, even if it's somebody talking trash on the video, report them for defamation and whatever else. You guys can send, and to the people out there who have sent me donations through Black Site 32, I won't mention names, But one of the donations was $100, so you know who you are. So thank you in advance, and all the other people. Thank you, thank you, and thank you. And I truly mean that. This isn't just, like a static robotic thing from YouTube or whatever else. Thank you. I do see your names when you guys join the Wolf Pack by going to YouTube, my main channel, and then clicking the join. You can still be a part of that, and get the behind the scenes information and special offers and things, and commentary and whatever else. You can find my social information on Blackside 32 on the social page. You can find passport information on the passport page. You can find lots of ways to help with the bills, reduce them, and whatever. Also on Blackside 32, lots of offers and discounts and whatever else. So guys, I'm really trying to give you guys everything that I do use and have worked for countless thousands of other people. So, and I'm hearing people that are out there forming groups on Facebook based off of me and my information. So thank you for that. Thank you for the shout outs. And it's funny because even though the people who don't give me shout outs on their channel because they want to hog all the glory and fame, it's funny because other people still know where the information's coming from. No, not all of it's mine. So I'm not going to lie and say it's all mine. I'm not even going to say that all of it's perfect or perfectly interpreted. That is subject to you and your arguments with the law. So, but what I will say is that I'm just a guy down the block doing the best he can, like everybody else. I'm not here to bring anybody else down. Like some people out there who take away from various people of their own uh, race and intelligence and whatever. We're not here for that. We don't have time for it. We're not in the zoo. I'm not a monkey. I'm not going to fling feces back and forth with other people. That's childish. We're here for God, liberty, light, your rights and freedoms, and helping each other. And if you're not a part of it, if you're not with us, then you're against us. And you have that right, because that's the best thing about America. It's rights, freedoms, choices, liberties, the pursuit of happiness. So if it makes you happy to be against me, then go for it. Because all you're doing is making my name get out there even more than I can possibly have expected. As for the rest of the beautiful people out there who are just doing your best on a daily basis, keep fighting. Keep fighting. Make them rue the day that your name popped up on their desk. Keep fighting. If you're in a position where you're not making much money or you need more education, there's lots of things I have to offer on Black Site 32 to help you guys out. So by all means, go and check that out, or find somebody else who's trained and professional to do it. Everything you want is at your fingertips through that phone, through your laptop. So use it wisely. Stop allowing for these trash entities and corporations and whatever else that are making money off of your time, focus, and attention. All right. So be your best out there. I will talk to you guys later. Badwolf is out, and I'm going to get ready to make the next video for you guys. So talk to you later. Peace and blessings and light to everybody. And to the rest, make yourself happy. Check you guys later.